Thank you.
SJC-11319, Commonwealth versus Jackson.
Yes, good morning.
May it please the Court, Attorney Ilse Nearing, representing Kyan Jackson. Mr. Jackson's case represents two major issues. The first issue is whether there is a search incident to a civil infraction for a decriminalized amount of marijuana, whether that search is legal. And second of all, whether three men sharing a marijuana cigarette on a park bench during the Hemp Fest are drug distributors. The short answer to these issues is no. For if it was otherwise, the intention of the electorate in the sensible marijuana policy would be defeated, and the Commonwealth's goal of perpetuating the police policy of ferreting out marijuana would continue.
Well, let me ask you. Let's assume that you have a case in which somebody is smoking marijuana. Police seize them. No doubt the police officer can give that person a citation, correct?
Yes, Your Honor.
And let's assume that he sees some marijuana sitting on his lap, on the lap of the person. Can he not grab that marijuana and seize that marijuana?
If a police officer sees a gentleman on a park bench holding a decriminalized amount of marijuana, I believe the statute says that there shall be a forfeiture incident to the writing of the civil citation.
So he can seize it if it's in plain view?
Obviously, and that's what happened in this case, the little marijuana cigarette seems to have evaporated. We can only assume it was ground in the ground.
Okay. How about in his pocket, he saw hanging from his pocket, he saw the baggie. Is that not also in plain view?
No, Your Honor. The little baggie was in plain view. However, the contents of the baggie was not in plain view. The contents of the baggie was inside the pocket.
Could you see, was the testimony that you could see any part of the contents or not?
I don't believe so, Your Honor. It wasn't described as such in the transcript. So that the police officer wasn't in a legal position inside the pocket to see the contents. And baggies, even the officer conceded, have many legal uses. And in addition to that, there was really no description of this particular baggie which indicated that it was being used for a criminal purpose or that it contained more than an ounce of marijuana.
Well, it doesn't matter if it contains an ounce or not in terms of forfeiture.
Well, Your Honor, the statute is about forfeiture of the marijuana, but the police officer had no idea what was inside the defendant's pocket when he
Well, he had a very
tugged.
good idea, actually.
I beg your pardon?
I think he said he had a very good idea, not absolute positive, but a very good idea of what was in that baggie in light of what was going on the bench.
Respectfully, the officer had a hunch.
Oh, I think it's more than a hunch. Don't you think? A guess? You think it's a guess?
On that premise, then, police officers on a hunch or suspicion or will be searching all citizens
With
for...
baggies in their pocket? No, this is someone he's just observed smoking marijuana. This isn't a person on the street with a little plastic bag hanging out of their pocket.
And this was at a hemp
And a
festival.
hemp fest.
At a hemp festival. But let me just following up on that. Suppose it was, we're not going to quarrel about whether or not it was in plain view. Suppose it was in plain view that there was something was sticking out. It looked like marijuana, and it's pulled out. And even if it's less than an ounce, but suppose it's in like little bags inside of a big bag. Is that distribution? Or is that probable cause to think that distribution might be happening?
If the little baggie pulled out of the pocket has 2 or 3 little knots inside of it, it is not reason to believe that it's possession with the intent to distribute, or there is no distribution there. It's in his pocket.
At a hemp festival?
No, because this is the way he may have acquired it for personal use. The possession of less than an ounce is decriminalized, and it's entirely
But
consistent.
possession with intent to distribute is not decriminalized of any amount.
Well, that wasn't really the issue in this case.
No, I'm just asking, at what point, can the police officer go further? You're saying the police officer can't go further than taking and forfeiting the marijuana taken in connection with giving a civil fine. Your problem is the backpack, right?
Yes, the issue is what was inside the sherbet container stowed inside the backpack. Apparently what was in the pocket just was a small amount with no little baggies or anything.
Right, so you're saying that doesn't give the police officer enough to then go
Into the
backpack.
knapsack. Absolutely, Your Honor, because that would essentially be a search incident to a civil infraction and would be allowing the police to search citizens and all of their possessions and their bags and containers stowed inside bags on suspicion of a civil infraction. And it's basically what happened on the Boston Common that day was a ferreting. And the officers themselves testified over and over, it was an investigation, a drug investigation. They had some marijuana. We thought that they would have more. They were searching it was an exploratory search for whatever they could find. And eventually they opened up this plastic sherbet container, and then he's arrested for possession with the intent. They had no idea what was going to be at the end.
Well, I take it you're not suggesting that by decriminalizing the possession of marijuana, it's been taken out of the realm of law enforcement because it's still contraband, subject to seizure, subject to a civil penalty. Police can certainly, as I understand it, we're on the Common to monitor and to actually hand out civil citations. Perfectly appropriate, right?
Yes, Your Honor.
So they were looking for marijuana. What's wrong with that? I mean, that in and of itself isn't contrary to the statute. What you're talking about is these invasive searches where, in the context of what appears only on the face to be a civil problem, right?
Yes, Your Honor. It's a question of proportionality. I mean, are citizens going to be searched for evidence of civil infractions? And the intent of the electorate was that less than amount of marijuana would be decriminalized. And so, as even written in Cruz, that when we commit a civil infraction, we simply expect to have our ticket handed over to us. And
our marijuana seized, I assume.
Yes, the marijuana in the cigarette obviously has disappeared. Somehow it was seized and ground away. But we don't expect to have our persons entirely searched. As the police testified, they had some marijuana. We would be looking for more. And then to have his backpack opened up and then have his plastic sherbet container open up. That is not proportional and reasonable to what was seen in the Boston Common that day of sharing a marijuana cigarette.
Okay.
Anything else?
Is there anything added by the fact that at some point your client, who's been seen smoking marijuana in public with two other people, whether or not in plain view, marijuana taken from a pocket, and as the police look at the backpack, your client says, "Don't touch my bag. Don't touch my bag." And the Commonwealth suggests that together gives the police reason to think something like contraband is in the bag.
No, Your Honor, I don't believe that gives probable cause or consciousness of guilt on the part of the defendant. there are many reasons why a person would assert his right not to have his possessions touched or moved or searched. And this was cited in Wong Sung as well, that any ambiguous conduct would then be construed to be searching and seizing citizens. And as we can see, that when somebody has an intent to want to perform a search, any kind of conduct will somehow be able to be expanded into being suspicious. And I just don't think that a citizen should be penalized for expressing his desire not to have his possessions searched and seized, particularly in this context when he's already being searched. It's inevitable what's happening here.
Attorney Nearing, is the question of sharing marijuana, should we decide that on the basis of joint possession, or should we decide that on the basis of saying sharing is simply not distribution?
Sharing, Your Honor, is absolutely joint possession. I think that if we look at Commonwealth versus Lawrence, which is 69 Massachusetts Appeals Court 596-603, that was the entrapment case. That on page 603, it quotes from Black Law Dictionary, stating that in criminal law, a person distributes a dangerous drug when he would sell or transfer. And I think that, operative here is in criminal law, a distribution of a dangerous drug. I think that the sensible marijuana policy has shown us that possession of less than an ounce is no longer considered a dangerous drug. In fact, the people's intent was clear. Possession of 1 ounce or less of marijuana should not be considered a serious infraction worthy of criminal sanction. And that was page 471 in Commonwealth versus Cruz.
What about the Johnson case?
I think Johnson also, too, reflects the notion that people can jointly and communally share a substance personally, each personally, and they're sharing it. And I think that that notion is actually manifested in our popular culture. If we credit the amicus brief and the federal research that 67% of all marijuana users share, if we just reach into popular culture, we see all the way back to Woodstock that people are sharing marijuana. They're always sharing. And that's the Hemp Fest. That was there that day.
Do we apply the same reasoning for people sharing a pipe with crack cocaine?
No, Your Honor, because the possession of any amount of crack cocaine continues to remain illegal in this Commonwealth, and the simple possession will get a person time in the House of Correction.
But if people are sharing a pipe of crack cocaine and they're passing it back and forth, is that distribution or is that just joint possession?
I think that is a fact-driven situation, and we have Commonwealth versus Johnson. But if we shift that over to the marijuana smokers with one joint between the three of them, that is joint possession, because the less than the ounce is only a civil infraction in this Commonwealth. And I think that this notion is so clear in the fact that prior to the sensible marijuana policy, we never prosecuted 3 people on a park bench passing a cigarette as drug distributors. This notion has only come up since very recently in the wake of the sensible marijuana policy. And I argue that it is suddenly important and has to be decided.
Now, is that something we can take judicial notice of?
I beg pardon?
How do we know that we never prosecuted 3 people on a bench before? I'm just interested when you say we never did before.
I have never seen a case where 3 young men, 5 young men, sharing a marijuana cigarette were prosecuted as drug distributors. And even in the facts of this case, the police officers testify, oh, we were writing civil infractions. And they obviously, the other 2 so-called distributors were let loose with their tickets. So it was even treated by the police as a simple possession at the day of the arrest and in the lower court.
Counsel, your time is up.
Thank you.
Good morning, Your Honors. May it please the Court, Zachary Hillman on behalf of the Commonwealth. We're asking this Court to affirm the denial of the defendant's motion to suppress in this case. When these officers happened upon these 3 gentlemen, they were sharing a joint, they saw that these men were distributing the drugs. As that term is defined.
If it's not distribution, is it over?
No, I don't think so, Your Honor. I think it's a much closer question. But we have several facts here that are distinguishable from what we had in Cruz. In Cruz, there was the odor of burnt marijuana. Here we have actual marijuana. We have these gentlemen being at a fest, which promotes the legalization of marijuana, in which the officers were specifically detailed for that day to watch for drug violations. We have what I would argue is a plain view observation of the baggie of marijuana in the defendant's shirt pocket.
Baggie. We don't know that it's marijuana, do we?
Well, you're right. There's nothing in the record where the officer testified, I could see marijuana in the bag. But he did testify that in his experience, marijuana is almost always kept in a plastic bag sticking out of the pocket, similar to the bag sticking out of the pocket of the defendant.
So the baggie was in plain view, but the contents of the baggie was not in plain view.
That's right, Your Honor, and I would suggest that the criminal nature of the baggie was apparent to the officer when he happened upon it.
The judge says in his written findings that discovering some contraband may search the immediate, the police who do that, may search the immediate area as well as the defendant for more contraband. Is that your position? That, in other words, that each of these, by virtue of the fact that they were sharing, and put distribution aside for a minute, just say it's,
Sure.
assume that it isn't distribution, that it is okay if police see 3 people sharing a marijuana cigarette, which they can seize, no question about it, they get to search each of those people for other marijuana on them?
Well, certainly before Cruz we would have said that.
Right, but we're not before Cruz.
And I think that in these circumstances where the officers see actual marijuana and they
In the cigarette we're talking about now.
and in the bag sticking out of the defendant's pocket, and let's assume, maybe I'm assuming too much, but let's assume that once they pull that bag out, it's evident that there's marijuana in that. Under the statute, this officer has a duty to seize an object that is subject to forfeiture, which is the marijuana. And I think that's what makes the discovery and the actual observation of the marijuana is what distinguishes this case from Cruz. Absent that.
May I interrupt you? Just
Absolutely.
so I want to be clear what I'm hearing you say. So just the sight of a baggie, without knowing what's in the baggie, was criminal? Is that?
That's not what I'm saying, Your Honor. What I'm saying is the sight of the baggie by an officer who has training and experience, and in his experience, the baggie that he sees is the type of baggie that marijuana is always kept in, would lead him to believe that
Well, a baggie's a baggie, right?
a baggie's a baggie, right?
Yeah. So seeing a baggie automatically means that there's marijuana in it.
In this officer's training and experience, because that is how marijuana is commonly stored, coupled with the fact that he sees these gentlemen passing marijuana back and forth, coupled with the fact that they're at the hemp fest.
But so we have a statute now that says it's subject to forfeiture. That gives you the right to search a person for more forfeitable stuff?
Well, I would suggest that it does. To the extent that this court disagrees with that position, I think that in these circumstances, And although it's also a close question, the officer here had reason to believe that there may have been a criminal amount of marijuana in that bag once he got to it. Given the smell of the marijuana that was coming from the bag, given the defendant's statements, "Don't touch my bag," as the officer got near it, coupled with the fact that they were distributing marijuana back and forth.
I take it the officers were moving the bag in order to pat frisk the defendant, and that's when he said, "Don't touch my bag."
That's right, Your Honor. That's correct.
So if the pat frisk was not appropriate, certainly what followed wouldn't be appropriate.
I would agree with that, Your Honor. I would agree with that.
Does it matter that, go ahead.
And the pat frisk is justified by fear? There's no fear here.
No, there's no fear here.
So you're saying that this is a search incident to a civil forfeiture?
Or, as I argued in my brief, a search, probable cause to believe that that bag contained more than 1 ounce of marijuana coupled with exigent
Probable
circumstances.
cause to believe the bag taken from the baggie?
No. That is
But
one
we're
factor.
only on the pat frisk now. Just
Okay,
the
I'm
pat
sorry.
frisk.
I'm sorry to
Okay,
confuse
so
the court.
let's
I'm sorry to confuse the
let's take
court.
it step by step. He sees marijuana. No doubt he can take the marijuana he's smoking.
Right.
Give him a citation. Let's put aside. Let's assume that he sees the bag in plain view, and we'll give you that too. Okay, so he has the. I'm not sure we will, but for the purposes of my question, we will. So he sees this bag in plain view, and he's taken the cigarette that he was smoking, and then what can the police officer do at that point in time?
Well, I mean, frankly, if under Cruz he doesn't have the right to search that person for more contraband, to believe that there's more contraband, I think the search has to, the search ends at that point.
Okay, so you're not claiming there's a search incident to the forfeiture?
No, I didn't argue that point in my brief. I do think that Cruz probably forecloses that point.
So put that aside. So
Right.
he can now do more than that if he has what? If he has probable cause to believe what?
That there's a criminal amount of marijuana in that bag,
And what?
in the backpack.
And
the
what is,
backpack.
and what is the basis to believe that there was probable cause to believe there was more than 1 ounce of marijuana in the backpack?
There is the marijuana that they recovered in the joint, the marijuana they recovered from the pocket of the defendant. The fact that these gentlemen are at the Hempfest, which is an area where the officers were detailed to enforce laws against the distribution of marijuana, and I would, if he was, I think at that point that's the probable cause to believe that there might be
So
more
everyone
than an
at
ounce
the
of marijuana.
Hemp Fest was suspicious of having more than an ounce of marijuana?
No.
Well, not unless the officers saw actual marijuana recovered from the person, and as they did here.
Well, you mentioned before that what added to it was that the officer, I guess, testified that he smelled marijuana in the bag. Is that right?
That's right, Your Honor.
Now, the judge didn't find that, as I see it here, did he?
That's right, Your Honor. I would suggest that the judge credited the officer's testimony implicitly.
Would not suggest that he did.
I know I would.
Oh, you
I would
would
suggest that he implicitly credited the officer's testimony. He certainly didn't discredit any of the officer's testimony, and I think that certainly this reviewing court can.
What did the officer testify to? Did the officer testify that while he was standing there and grabbing the baggie, from that distance, that erect posture, he could smell the odor of marijuana from the bag, or did he have to already be picking up the bag?
No, admittedly, Your Honor, it was when he picked the bag up.
So he was already touching the bag.
The backpack we're talking about.
Yes,
the backpack.
that's right.
Yes, Your Honor.
If this had not been a hemp fest, but had been, the middle of August somewhere, other than a hemp
Shakespeare,
fest.
Justice
Yeah,
Strickland.
Shakespeare Festival. Would probable cause exist?
I think that's a much closer question.
Unless Shakespeare was known to be a...
Yeah.
Right, Your Honor. I think that's a much closer question. I do think the fact that these gentlemen were at the Hebfest is a significant factor.
Now, let's go back. Your first argument was essentially sharing is distribution to the extent that it involves a transfer. Was that argument made below?
That was not, although I would point out that this case was decided by the motion judge prior to Commonwealth versus Cruz, about a month before Commonwealth versus Cruz. I would suggest that this court can affirm the denial on any ground supported by the record, and I think the facts here support probable cause to believe that these gentlemen were engaging in the distribution of marijuana.
All three of them?
Yes, Your Honor. Yes.
Oh, because of the sharing of the cigarette?
That's right, Your Honor. That's right.
Do we, is the sharing of a cigarette, is it joint possession or is distribution something different?
I think it's distribution. And I think the question of whether it could be joint possession is a question for the jury. The officer who comes upon these gentlemen isn't required to exclude all possibilities. And in fact, where he sees what is defined by the statute, the transfer of marijuana from one person to another, he has probable cause to arrest. At trial, if the defendants want to assert the affirmative defense of, I only possessed it jointly with these gentlemen, that's certainly a trial issue. But at the probable cause stage, these officers had probable cause to believe that these gentlemen violating the statute.
So the takeaway from your position is that it's better for people to have their own joints?
Yeah.
So that if they were at the Hempfest, they would have done better to each of them have their own joint?
Yes, Your Honor. Yes.
Now, going back to Johnson, I mean, in Johnson, as I recall, two persons go together to purchase cocaine. The person hands one person the cocaine, and then that person gives the other person half. And we say, well, it would sort of be silly and unfair to, if they had split the half, if the dealer had split them in half and given them each half, neither of those two would be guilty of distribution. So it seems silly and unfair to charge, simply because they happened to give it to one who then gave half to the other, to charge that person with distribution. Isn't there sort of a similar principle here? That it's sort of a little bit that depending on who, if the person pulls it out of the pocket, whereas the person who last receives it is not distributing, they're the person last to get it. And if it's used up by the time the last person, then that, I mean, aren't we in the same silliness game here?
I think that's an excellent question for a defendant to make to a jury. If the case gets so far to be charged as distribution. Again, this is a circumstance where it's the executive's decision whether or not to charge these gentlemen with distribution. We, in fact, did not, even though we could have. And, you know, if that is the case where they're charged with distribution, it's up to the jury to determine whether or not it's simple possession, joint possession, or distribution under the statute, under the reading of the statute.
But here he was charged with possession with intent to distribute, correct?
Based on the amount of marijuana that was in the sherbet container in the backpack.
Not on the basis of what they saw initially.
That's right, Your Honor. That's right. And I just want to very quickly, Justice Cordy, in Pacheco, you asked the question, you know, did the voters have in mind that sharing would equal distribution? And I would suggest that, yes, they did when they looked at question 2. The drafters of question 2 were aware of what the definitions of distribution were under Section 1. Johnson was out there. Lawrence was out there. All of this information was out there that would have led the drafters to understand that the sharing of a joint is distribution, that the changes to the statute through Section 34, which excludes possession of less than 1 ounce of marijuana, there's no similar amendment to Section 32A-C, which is the distribution statute, or also the definitions under Section 1, I would suggest shows that the drafters of the legislation did not intend to exclude the sharing as that is defined by distribution.
To your knowledge, now, I've been unable to find any appellate case that talks about the sharing of the use of a narcotic as opposed to the transfer of a narcotic for someone else's use as distribution. Are you aware, in your experience, the experience of your office prior to this referendum, of that ever being prosecuted as distribution?
Personally, I'm not.
Okay, and there's
I don't want to
there's no
speak.
appellate cases that deal with that at all.
Well, there is the Lawrence case. There is the Lawrence case.
More about the Lawrence case.
The Lawrence case was the entrapment case that my sister mentioned. In that case, the defendant handed over a joint to an undercover police officer for exchange for $20. The appeals court said that the entrapment defense wouldn't have been appropriate in that case because this particular defendant was prone to distribution because he had shared marijuana with his friends earlier, and that the sharing of the marijuana with his friends equaled distribution as that term is defined by the statute.
And that's your authority, but the person wasn't, of course, charged with that.
He was charged for the actual distribution
Right,
of
right,
the
not-
yes,
To the undercover
to the
officer.
undercover, right.
of
That's
course.
correct, Your Honor.
Of
That's
course.
correct, Your Honor.
Okay, thank you.
Thank you, Your
Thank you
Honors.
very much.